2 cases approved, PD request granted, case has been dismissed. In this video, I am going to talk about this great news for our clients. My name is Bijoux Ngwanda, as you know it. I am an immigration lawyer based here in DC. However, I do have clients across the country and around the world because we are dealing with complex U.S. immigration law cases. If you're new to my channel, please go ahead and subscribe. If you are not new, welcome back. Thank you for subscribing. And please do not forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, you go ahead and share, like. Don't forget to comment below. Also follow me on all platforms. Links are in the description box below. We have 2 great news to share. The first one is Chicago, Illinois, OPLA in Chicago, Illinois. Hello, saying hi to our good friends in Chicago. What's going on with the case was that my client was in removal proceedings based on an NTA, mandatory NTA notice to appear, because the first petition was denied with USCIS. And you will think that because this is a pending case, it's obviously a non-priority case, I should just agree to dismiss the case so we can adjust status with USCIS. That wasn't the case, okay? We started talking to OPLA ICE in Chicago in February 2024 with no response, just automated responses until the day of the trial. So, but again, before trial, we had to renew the PD request with FBI background check, of course, the most recent background check. And we had to appear in court because we had to take pleadings. So we took our pleadings, we entered the pleadings, we had to enter pleadings, sorry. So we enter our pleadings and we ask the department position on the PD request. Because why? Because first of all, this case, it's not a priority, although it's a mandatory removal case based on notice to appear, because, you know, when a case gets denied, DHS has to, as a matter of law, issue a notice to appear because it's mandatory, right? So, and by the time the notice to appear was issued, we did not have this dolly memo going on. So we had to explain that this case, first of all, is not priority. The case was just denied because, sorry. The case was just denied because the waiver was not approved. Because remember, if you are not admissible based on certain grounds, you have to file for a waiver. So the waiver wasn't approved, so the case was denied. Then the person finds themselves in removal proceedings. But we have an alternative type of defense. We filed a VAWA, which we had a prima facie determination letter already. It has been issued by USCIS. So we had to explain that to the court. First, the case is not a priority, even though it was brought to removal based on mandatory notice to appear. It's not a priority, and we have an alternative defense, which is VAWA, and USCIS has issued a prima facie letter determination, meaning that our client will adjust status, right? Because, of course, they're a VAWA self-petitioner, and it looks like the case has already received a prima facie letter determination. And we waited for the ICE to respond, and then they agree. We joined the motion right there in court orally, and basically the judge granted the motion on the spot. Great victory. This is the moral of the story. If you are in removal proceedings, it's not because your case, just because your case is not a priority, it doesn't mean they're going to grant you the PD request. Sometimes they just don't. That's what happened with our client. They did not agree for 4 months until the day of trial, because we had a lot to show to them that we have an alternative way of going about this case with USCIS. As a matter of fact, on a PD request in Chicago, it clearly says that if the person is brought to removal proceedings, even if they are not a priority, the fact that they are being brought to removal based on mandatory notice to appear, ICE has to dig in and check and see whether or not either they file a frivolous claim with USCIS. That's why the case got denied. That's why they've been brought to removal proceedings, or they've been placed in removal proceedings. They have to dig. So that's why I guess they didn't really agree with us until they got all our documents, prima facie determination letter, explanation, FBI background check, clear. So now my client can finally register status with USCIS. We already filed all those other petitions to supplement our pending VAWA petition. We filed the green card application I-765 and I-131 because my client really has to go home to meet with her family, because a lot has passed, a lot has happened since she has been living here in the United States since 2010. So it is really a relief, not just for me, for our client, because anytime soon, because right now they're approving those advance parole, just like that, as quick as possible. So we hope that in 45 days, she should just be able to get the parole and go home to fix her problems home, then come back. First, great news. So the second great news, again, this is a case here in Baltimore. Trust me, we thought because the case is pending, it's open, the PD request should be just easy. We had to appear in the first master hearing to enter pleadings because the judge wants to know what's going on. So we entered those pleadings, and I said that we needed to submit another background check. So we had to submit another FBI background check, and we have been waiting. Finally, yesterday I received an email saying that they agreed to join motion to dismiss the case. So I filed a motion to dismiss, and now the judge has granted that motion to dismiss as well. So how long does it take for ICE to respond? When a case is open, it's not supposed to take that long, but in our case, it took too long because they're just waiting for the day of trial to review all the documents. Another reason it took too long because they really wanted to make sure that, although it appeared that it's not a priority, they just want to know the reason why. First of all, the case was denied by USCIS, so they had to make sure that there's no frivolous claim or misrepresentations going on with those cases. So in total, it took at least February, March, April, May, June, 5 months, around 5 months. So because a lot of people always ask, how long does it take? How long? In those two cases, 5 months, okay? But when the case is closed, how long is it going to take? It just depends. Each circuit, each state, different. I've seen cases from 4 months to 6 months to 9 months to 2 years, okay, before ICE agrees to reopen an old case, especially when the case is closed, order of removal has been entered. It's just patience is required. And you need proper counsel. You need legal counsel. You need somebody who knows how to communicate and how to negotiate with ICE. Because especially when you're trying to ask them to reopen an old case, it's just not, they just don't have to agree anyway. So you need someone who knows how to negotiate, someone who knows how to write those motions properly, someone who knows how to enter those documents and advise you properly on what steps to take. Again, my name is Bijoux Ngwanda, as you know it. If you need a consultation with me, especially to reopen an old case because you have some type of application that has been approved, or the case is pending, you need a dismissal because it's not a priority. Even if it's a priority, if we have mitigating factors, we can demonstrate to us that those factors can be mitigated. So, for example, let's say the person had some type of criminal records. If we can prove that those crimes can be waivable, they are waivable, they can be waived. We can try to communicate and mitigate those factors. If there is rehabilitation, those factors can be mitigated. We can try to negotiate. Okay, that's why you need counsel. By the way, you can schedule your consultation by using the consultation link in the description box below. Until next time, bye bye.